Imagine a dam that is almost 130 years old, sits within a state of India, but is completely operated and managed by the other state of India. Now, this is not a hypothetical situation. This actually is true, and this is the story of Mullaperiyar Dam. The dam sits inside the state of Kerala, but is operated, managed, and the water from this dam is used by the neighboring state of Tamil Nadu. In this particular video, we are going to understand that why Mullaperiyar Dam keep coming in news every now and then. What is the reason behind the dispute between the state? How is it related to a colonial-era agreement that was signed between the Madras state as well as the Travancore state? And why recently the Kerala chief minister has talked about this dam, saying that he would fund the dam construction of a new dam and would dismantle the Mullaperiyar Dam if Tamil Nadu agrees to it. So let us try to understand this in more detail. Now, first of all, to understand that why are two Indian states fighting over the water, let us try to briefly revise the understanding about the dam. Now, dam is about 131 years old. The reason behind dispute to some extent emanates from this fact itself. Because of the aging infrastructure, Kerala government believes that continuously operating this dam would put millions of people and their life at risk in the east of Kerala. Now, if we talk about this particular dam itself, 999 years, that is the number of years for which lease was signed between the Madras presidency and the Travancore state as such, that used to be somewhere in the period 1880s. The total 152 feet is the demand of water level that should be raised as per the Tamil Nadu state as such, that would fulfill the agricultural need and other needs of the particular state. Now, in August 2026, as we have discussed, Kerala's Chief Minister V. Satheesan, he said that we will create a brand new, will fund actually a brand new dam and let Tamil Nadu pick the location, let Tamil Nadu operate and manage it the same way it is operating and managing the Mullaperiyar Dam. On the other hand, Tamil Nadu has rejected this particular proposal. Tamil Nadu's stand is clear. It states that dam is safe to operate even though more than 130 years has passed and no new dam creation is required as such. At the same time, the state government of Tamil Nadu has asked that water level in the dam should be raised. This happened in the recent meeting of Southern Zonal Council between the Chief Minister of Tamil Nadu and the Chief Minister of Kerala as such. Now, the core question that seems to come or emerge from this entire discussion is that whose safety concern and whose water right should be given preference. Who would win in this case under a lease that is still being operated, that was framed in the colonial era. Now, let us try to understand also geographically where is the disputed area. Now, location of this particular dam we can see by taking a look at this map itself. If you take a look at this map, you can see here, this is the Mullaperiyar Dam. It is at the confluence of two rivers, one river that is called as Periyar river, another river that is called as Mullaperiyar river. Now, further from this, the dam water is diverted to the channel in Tamil Nadu through a river system, through a river that is called as Vaigai river as such. Now, to understand, this is not a river sharing dispute. The dispute is clearly related to the use of the Mullaperiyar Dam. Kerala cites it's a safety concern, while Tamil Nadu says that it is safe, dam is still safe to be operated as such. Now, in Tamil Nadu, when the water is transferred, we can call it as an interbasin transfer through the Vaigai river channel, several districts of Tamil Nadu such as Theni district, Madurai district, Dindigul, Sivaganga and Ramanathapuram derives benefit from it. And to some extent, it is also rooted in the geological or geographical structure of this region. You know, in geography we have studied the Tamil Nadu lies in the rain shadow areas of the Western Ghat, and that's why we do not have sufficient amount of rainfall in the eastern slope of the Western Ghat. That's why this area historically, geographically have remained a drought prone and arid region as such. That's why the dependency on Mullaperiyar Dam's water is humongous for the people here. Who bears the risk? Obviously, because the dam itself is located in Kerala, any structural failure due to the seismic activity, due to the reservoir induced damages and all that would have to be borne by the district of Kerala such as Idukki, Kottayam, Ernakulam, Alappuzha and Pathanamthitta district of the Kerala as such, which is located to the downstream of the dam. Now, also we have to understand the dam as per Kerala lies in the seismic zone. Now, not seismic zone of very high probability earthquake like in Himalayas, but of moderate probability earthquake definitely can be seen here, because though Indian plate is pushing against the Eurasian plate in the northern part, the entire plate gets stressed. And that's why you have a kind of Idukki lineament where the crustal fracture and fault is observed, and that's where the probability of earthquake is. So, if any earthquake takes place in Idukki that can compromise the safety of Mullaperiyar Dam, that's at least the stand of Kerala. So, because of this reason, it would failure would endanger millions of people's life in Kerala's own downstream district. That's why it considered it as a safety hazard. Tamil Nadu gets the water, all diverted water for irrigation, with no share of structural risk sitting inside its state, as the entire dam is located in Kerala. So that is how we can understand geographical and tectonic setting for this entire dam. Now, before moving forward, I would want to bring your attention to the fact that at Legacy IAS Academy, we are going to soon commence batches. The regular weekday batches are going to start on 7th of September and 3rd of November. Their classes will go on from Monday to Friday between 10 to 5 p.m. Weekend batches for students who are preparing for the examination along with a full-time job or studies is going to commence on 10th of October and 12th of December, where every Saturday and Sunday you have class between 10 to 5. Now, in this particular course programs, we ensure that comprehensive coverage of GS paper is carried out, and also as students require support even outside of classroom, we have dedicated one-to-one mentorship sessions and doubt solving session. We encourage regular interactions with the faculty member and also within class to ensure that there is a general interactiveness. We ensure that maximum 40 students are permitted per batch. Now, also we know that in the case of UPSC, prelims and mains preparation requires an integrated approach, and that's where the daily mentions writing practice, the test series, appearing in test series, evaluating the performances becomes a very critical part which we have duly focused upon. Now, if you want to know more detail about the course programs in future, you can click the link in the description box of the video. You can also scroll through our websites and can download our Legacy IAS app. Now, coming back to the topic, if you look at the entire history of dispute, it was the year 1886 where Periyar lease agreement was signed. The duration for this for which this lease would be active was decided to be 999 years as such. The deal was signed between the British government, who was that time managing the Madras presidency, and the Travancore Maharaja, that was the independent state. Then further in 1900s, the dam was completed, a building was completed, and the water began to be diverted into Tamil Nadu region. As we have discussed, the water is diverted through the Vaigai basin of Tamil Nadu, the river along the bank of which Madurai, the temple city, is located. It was year 2006 when the dispute began to again, dispute again began to rise between both states, and Supreme Court permitted that water level in the dam can be raised to 142 feet, which was earlier 136 feet as such. Kerala then passed the law as a reaction, capping it at 136 feet by passing it through its own state legislature. But again, Supreme Court, the matter was referred to it struck down this particular capping of Kerala's capping law, because it said that it is unconstitutional. The state government, by bringing a law through its own state legislative assembly, cannot override the agreement that was signed earlier between both states. Unilaterally, a state cannot withdraw itself from any bilateral agreement as such or interstate agreement as such. In 2021, Dam Safety Act was brought in by the Parliament of India, which created two major authorities: at national level, National Dam Safety Authority, and at state level, State Dam Safety Authority. It was in year 2026 again. The matter is heating up because Kerala has said that dam still poses a structural safety hazard that can risk millions of lives of people in its state, and that's why it is ready to fund the entire new dam, even giving Tamil Nadu every right to decide which area, which place. And Tamil Nadu then demand that dam is currently operational, there is no safety hazard based on its analysis, and the water level should be raised from 142 to 152 feet as such, so that more water can be supplied to the Vaigai basin as such. It was August 2026, we already have discussed. Southern Zonal Council is where both chief ministers have put forward their idea as far as the dispute is concerned. Now, the legal architecture of this dispute, we have discussed before several river disputes between various states. This is not a tribunal dispute as such. That means there is no dedicated tribunal to tackle the Mullaperiyar dispute between the states of Kerala and Tamil Nadu. Whenever dispute has arisen and would arise in future, most likely it would be dealt in the Supreme Court in the form of litigation itself as such. And dam safety, not an interstate water dispute act tribunal. 2006 Supreme Court verdict is very important to understand, because Tamil Nadu was permitted to raise the water level to 142 feet based on the expert committee's safety assessment. Now, this is also Supreme Court has stated in the recent hearing also that just because Kerala has brought an law, it cannot override the analysis of the expert committee, which has made it very clear the dam is safe to operate, and that's why water level should be risen. Kerala's 2006 amendment was struck as it was considered as unconstitutional by the Supreme Court of India. That was the view of Supreme Court in 2014 as such. Now recently also under the Dam Safety Act, a team is expected to complete the safety inspection and submit its report in the coming weeks as such. And then only more understanding will have about how this entire dispute resolves. Now, a dispute measured in feet, that's how also we can define this particular dispute, because when we talk about the Mullaperiyar Dam, the Dam Safety Act created that we have discussed National Dam Safety Authority and a comprehensive dam safety evaluation committee, but two states now dispute who should sit on the very committee. That is also a big problem, because even if a committee carries out the inspection and let us suppose it says that dam is safe to operate, Kerala might object saying that it is not happy with the composition of the committee members, or if it gives different view that dam is not safe to operate, it should be dismantled or the water level should be lowered. In that case, Tamil Nadu might find it appeasing, and then it can also object to the composition of the members as such. That's why it is very essential that impartial committee which is accepted by both of the state, members accepted by both the states, so they should be made basically the members of these particular committee as such. Water level, again to look into the data, 136 feet that was permitted by Supreme Court, 136 feet was the original water level actually in 2006 and 14 judgment, then 142 feet was permitted by the Supreme Court, and the recent, that is 2026 demand of Tamil Nadu is to further raise by 152 feet as such. So also we have discussed before about in last video Ravi Vyas agreement. It is something similar to that. If you remember, I told you Punjab government also tried to unilaterally withdraw itself from the Ravi Vyas Satlaj agreement as such to legislate out of the dispute from Ravi Vyas region. Something similar was done by Kerala 2006 law, and both of the law, you will see one similarity here. Supreme Court has struck both Punjab's way to legislate itself out by state legislation, and Kerala's attempt was struck as such. Now each state's position we should also try to understand. So as far as the Kerala is concerned, its stand is very clear. It has been continuously saying the dam has vastly outlived any reasonable structural lifespan, and other thing is that it sits in a seismic active zone as such. The reason behind that we already have discussed. There is a crust, there is a fracture in the rock system of the Idukki because of the collision between Indian plate and Eurasian plate. Endanger millions across 5 Kerala districts. The 1886 lease. Other thing that Kerala object is that the entire agreement is based on a lease that was signed before India got independent. And it also says that the Maharaja of Travancore, that time, he actually was pressurized by the colonial authorities, by the British authorities to sign the dam so that Madras can reap benefit from it. It was effectively imposed on the Maharaja of Travancore. So first of all, the lease itself should be questioned. And then Kerala says that it is not questioning the lease, it is not making a fuss out of the lease because it understands that Tamil Nadu needs water from the western side, western rivers. So 2026 offer still stand, and it has framed its stand saying that we understand that water is important for Tamil Nadu, we do not have any objections about it, but at the same time the safety importance of Kerala should not be ignored. That's the stand of Kerala. As far as the state government of Tamil Nadu is concerned, its view is also exactly opposite of Kerala. It states that dam is structurally sound. The reason is because both the Supreme Court's report or Supreme Court has backed the fact-finding committee report both in 2006 and 2014 as such. Depends heavily on this water for irrigation across 5 historically drought-prone districts because they lie on the red shadow region of the Western Ghat. It argues that Kerala's safety objections are really about restricting its water access. There is no ground behind talking about the safety of dam. Kerala is using as a mechanism through which it wants to control more water from the Periyar and Mullaperiyar river as such. Points to Kerala's alleged delays in approving routine maintenance as evidence that Tamil Nadu has stated it can be clearly seen in the Kerala's stand such, and it opposes any decommissioning of dam. Rather, it says the dam is so structurally sound that we can even increase the water level from present 142 feet to 152 feet as such. So as we can see that both of the states have a large scale disagreement, and we can call it as a opposing view as far as this matter is concerned. Now where things stand in August 2026, again to repeat, the 2014 Supreme Court ruling up to 142 feet remains the operative legal baseline. That means Kerala is expected to ensure that water level in the reservoir in the Mullaperiyar Dam should stand at this particular level. Neither new position is yet adjudicated. That means Tamil Nadu's demand of 152 feet water still is not effectively, it still is not in effect, and Kerala's demand to dismantle dismantle the dam, still it has not been accepted by the Supreme Court as such. So, the dispute remains high profile in both states' domestic politics as well. It has influenced politics. We have seen many times the protest coming from both Tamil Nadu side and Kerala side around the border areas of the dam. Now, what mechanism exists to settle a dispute? So, first of all, a negotiated new dam agreement converting Kerala's funding and location offer into binding time-bound construction agreement. That would ensure that Kerala's safety assessment is also taken into consideration. And this particular way of binding time-bound construction agreement would ensure to the people of Tamil Nadu that Kerala is not only talking about the dam, rather it is very serious in constructing this particular project. So, they would be sure that in the future, they would not be at disadvantageous position, as they would have full right over the water that would be transferred from newly constructed dam as such. Second, a jointly trusted safety audit. One organization might say that it is not safe, other organization may say it is safe. Now, who to believe? Both state government might also disagree on the composition of such particular committee as such. So, resolving the CDS is a composition standoff. So, as a credible technical assessment can finally proceed. Entire decision in this matter should not be taken on the basis of the political game as such, or for example, what is in the best interest of the political parties. Rather, it should be a judgment based in the objective assessment carried out by the impartial technical committee as such. Full Dam Safety Act implementation, we have seen that 2021 was when Parliament brought in this act, using National Dam Safety Authority's statutory power we can use here to set binding maintenance protocol neither state can unilaterally block. So, that would also take care of the complaint that Tamil Nadu government has raised, that Kerala keeps on delaying many times, keeps on postponing this particular maintenance protocols that further create problems for people of Tamil Nadu. Then fourth, we can say a central government mediation, because Southern Zonal Council style forums that was recently held, it can act as a very good mechanism. It can act as a very important body to work out a negotiated middle path outside the courts, rather than delaying the proceedings and rather than dragging the matter in the court. Better is to bilaterally solve it by using Southern Zonal Council. Next is judicial clarity on the new dam question. A definitive SC ruling on the whether or how a replacement structure can proceed separates from the water level question. That can also be one way which we can explore. And guaranteed water supply assurances. Now, we know that a modern agreement replacing 1886 lease. One thing we have seen, which Kerala also sometimes brings, is that the lease was signed during the British time. That's why it should not be given so much credence. So, better we understand the reality of the situation is that though the Periyar river flows in westward direction, to a large extent the people of Tamil Nadu who lie on the rain shadow areas of Western Ghat depend upon the water from this river. This cannot be denied. So, even though you scrap the 1886 lease, a similar kind of agreement, a modern agreement signed between the two states now, Kerala and Tamil Nadu, can guarantee Tamil Nadu's access regardless of the structure's fate. Even in future, if the structure is dismantled, still a new dam would supply water to the state of Tamil Nadu. These are some steps we can take in the next coming few months and years to ensure that this matter is resolved. The question still is unresolved, unfortunately. An offer to build that was by Kerala has been rejected by Tamil Nadu. A demand to raise the water still has not been accepted by Kerala. Kerala wants to tear the old dam down. Again, to conclude, Tamil Nadu wants to fill it higher and higher until both states agree on what is safe and what is sufficient. Mean for the same 131-year-old structure, the Mullaperiyar dispute will keep resurfacing. That's all for this particular video. We will soon come back with a new video related to new dispute or another dispute between the states on the basis of the interstate river. Thank you very much.